Namaskar. Today we are going to do a quick revision in a simple language through a shared PDF notes on the subject of administrative law. You may download complete notes from the description link or from the first comment of this video. In this note, we try to cover all the major topics which are important for the law students and competitive exams point of view. Let's start the topic which all are covered in the entire notes are as follows. Introduction. We will see meaning of administrative law, object of administrative law, scope of administrative law, nature, sources, reason for the growth of administrative law, separation of powers, judicial review, principles of natural justice, doctrine of legitimate expectations, delegated legislation, control on delegated legislation, rule of law, Ombudsman, and finally local jurisdiction. So let's start on this topic. I will try to clarify each points briefly. So introduction, what is administrative law? तो administrative law is a branch of public law. ये एक unmodified law है. इसके लिए कोई specific sections या कोई acts इसमें नहीं होता है. Constitutional law is closely related to administrative law. Administrative law has separate legal existence from the 20th century onward. It regulates the work of administrative authorities. Before the 20th century, it was part of a civil law. What is the meaning of administrative law? Administrative law regulates and controls the actions of administrative authorities. Sir Edward Jennings defines administrative law as the law that controls and regulates the activities of administrative authorities. It can be understood as the law that deals with administration. Whereas Mr. Vale states that administrative law is concerned with the operations and control of the power of administrative authorities. And Mr. Robinson notes that administrative law deals with administration just as commercial law deals with commerce and law deals with land. Let's see the objective. Its objects is to oversee the activities of administrative authorities, to ensure the rule of law, to share the burden of government administration. Scope, maintain legal discipline, law in a realistic sense. It deals with the power and functions of administrative authorities, follow the principles of natural justice, maintain the rule of law, provide remedies to individual in case of violations of their rights. Regarding the nature of the administrative law, it is unmodified law. It is a branch of public law. It deals with the activities of administrative authorities. And the last one, it addresses the organization and powers of administrative authorities. Nature of administrative law is short that it's legislative or rulemaking, judicial or adjudicative, purely executive. Sources of administrative law, it's through constitution or statutes. Statutes मतलब acts. Reasons for the growth or development of administrative law, change in government philosophy, demand from the public, inadequacies of the legislative system, inadequacies of the judiciary system, principles of natural justice. सेपरेशन ऑफ पावर, किस तरह से पावर्स आर डिवाइडेड है इसके अंदर, वो है जैसे गवर्नमेंट फंक्शनल इंक्लूड लेजिस्लेटिव वर्क, एग्जीक्यूटिव वर्क एंड जुडिशियल वर्क. मीनिंग द सेपरेशन ऑफ पावर्स इज बेस्ड ऑन द प्रिंसिपल ऑफ 3 independent powers in a nation, namely the legislature, administration and judiciary. None of the government branches, legislative, executive and judicial, should exercise the powers of the others. They are to be independent of one another, and each can exercise only one type of authority. Historical background. Aristotle was the first person to write about the separation of powers in his book, which names Politics. It is deliberative, executive and judicial. Key contributors was Aristotle, originated the concept of administrative separation of powers. Locke defined the principle. Montesquieu propounded this theory. John Badlin 1530 to 1596, French political theorist who argued that a cruel king making laws would lead to unfair judgments. Mr. Locke, in his books Two Treatises of Civil Government, he discussed legislative, executive, and federative powers, foreign affairs. Montesquieu, in his books The Spirit of the Laws, he presented the separation of powers theory. Criticism of the separation of powers, historical inaccurate. Basically, it is historically inaccurate. In reality, the division of functions is not always possible, not feasible in a welfare state, practical difficulties in its acceptance. Indian law, separation of powers, not completely adopted in India but followed in a broad sense, like judiciary. Article 141, every judgment of the Supreme Court is binding on high courts. Judicial review, the power to review laws made by the legislative organ. Writs, a writ is a legal remedy in case of rights violation. Individuals can seek remedies through writs. सुप्रीम कोर्ट में आर्टिकल 32 के अंडर में हम फाइल कर सकते हैं कोई भी रिट, और हाई कोर्ट में आर्टिकल 226 के अंडर में. जो टाइप्स ऑफ रिट्स होते हैं वो 6 तरह के होते हैं. फर्स्ट है हेबियस कॉर्पस. It means you may have the body to release a person who has been unlawfully detained, whether in prison or private custody. Mandamus, we command, issued by the High Court or Supreme Court to secure the performance of public duties by lower courts, tribunals or public authorities, cannot be issued against the Governor or President of India. Certiorari, to be certified, issued by the Supreme or High Court to quash an order from a lower court that is beyond its jurisdiction. Prohibition, forbids lower courts from dealing with cases outside their jurisdiction. Quo warranto, by what authority? To restrain a person from holding a public office to which they are not entitled, especially if they are using a false credentials. In the starting of narrating the writs, I mentioned that writs are of 6 types, but it was wrong. The writs are of 5 types, which I already shared with you right now. Now the next topic is principles of natural justice. Natural justice is an expression of English common law originating from just naturally. It means law of nature. It involves procedural requirements of fairness. There is a famous case, Menka Gandhi versus Union of India, 1979. In that case, it has been narrated, natural justice is a principle that imposes fairness in law. Next famous maxim is that nemo judex in causa sua, rule against bias doctrine. Doctrines means siddhant. So no man shall be judge in his own cause. A judge suspected of bias can be disqualified from determining any case. A party or suitor, as well as the judge or deciding authority, must be impartial and without bias. It has been mentioned in the case Ridge versus Baldwin, 1963. Types of bias. There are 3 types of bias: personal bias, pecuniary bias, subject matter bias. Personal bias related to parties, relatives, friends, etc. Pecuniary bias related to financial interest. Subject matter bias, official bias, where the deciding officer is involved in the subject matter of the case. Next maxim is audi alteram partem. It means listen to other side. Means both sides must be heard and no one should be condemned unheard. There must be fairness on the part of deciding authority. It means दोनों पक्षों को सुनना जरूरी है, कोई भी ऐसा पक्ष नहीं होना चाहिए जिसको ना सुना जाए. रीजन डिसीजन, इसमें क्या है, स्पीकिंग ऑर्डर्स आर रिक्वायर्ड. इसके डिसीजन के लिए स्पीकिंग ऑर्डर्स आर रिक्वायर्ड. रीजंस फॉर जजमेंट नीडेड टू बी रिकॉर्डेड. Parties are entitled to know the reasons for decision. The famous case is Simons versus Union of India and Manteca versus Union of India, 1978. Sources of reasoned decisions are constitution, statutes, specific acts may require recording reasons, principle of natural justice and nature. Doctrine of legitimate expectations. A person should keep their word. This doctrine serves as a tool to review administrative actions and pertains to the relationship between individuals and public authorities. Public authorities can be held accountable. First discussed in India in the case of State of Kerala versus M.G. Madhavan Pillai, 1988. Delegated legislation. Delegated legislation. It means when law is made by an authority other than the supreme authority, legislature, executive and judiciary, it is also called subordinate legislation. As per Mr. Salman, it is subordinate legislation and it is supreme legislation. Delegated legislation, when legislative authority delegates the power to make laws to the executive authority, it is called delegated legislation. What are the advantages? Advantages are as follows. It reduces pressure on parliament, addresses technical issues like energy, nuclear, etc., provides flexibility, useful in emergencies. And what are the disadvantages? Disadvantages are as follows. Undemocratic in nature, complexity in laws, lack of publicity, problems in the wordings of delegated legislation. Classification of delegated legislation. It is title-based classification like rules, regulations, bylaws, order. Nature-based classification with limitations. Normal delegation, less than positive. Power with same restrictions. Negative, which is restrictive. Exceptional delegation gives absolute power to make laws, cannot be challenged by anyone. Delegated power through act is called the Henry VIII clause. Next topic is constitutionality of delegated legislation. The permissible limit within which the legislature as the sole repository of law-making power can delegate rule-making power to other administrative agencies. Let's see the positions of delegated legislation. In USA, delegated legislation is not allowed due to the principle of separation of powers. In England, Parliament is supreme and there are no constitutional limitations on Parliament. They have broad powers to delegate legislative power to the executive or subordinate bodies. And in India, there are two constitutional limits on legislative delegation. First, essential legislative functions cannot be delegated, which consist of determining legislative policy. Second one is power conferred on subordinate authorities should not suffer from excessive delegation. Norms of jurisprudence of delegated legislation. First, essential legislative functions cannot be delegated by the legislature. Legislative policy must be laid down and enacted. I am not explaining all these things in my own words because it's already written in the simple way. That's the reason behind it. There is no need to explain. Few words which are tough to understand, I am already explaining those words. Third one is, after exercising essential functions, non-essential functions can be delegated. And fourth one is, delegated legislation will be valid according to the Parent Act, means Principal Act. Control on delegated legislation, judicial control, its substantial ultra vires and procedural ultra vires. Substantial ultra vires means when the Parent Act is unconstitutional, if the Parent Act declares essential legislative functions, if delegated legislation is inconsistent with the Parent Act, it is inconsistent with general law, if it is arbitrary or unreasonable, if the delegate further delegates power, if it excludes judicial review. And procedural ultra vires, two procedures are required: publication and consultation. Other topic is legislative control. It means parliamentary control. Monitors executive work through the following means: proceedings in parliament, laying on the tables as question challenges to the rules entered, scrutiny committees. It used to scrutiny the committees. Procedural controls are as follows: operates in three components: prior consultation for delegated legislation, prior publicity of delegated legislation, post publicity of delegated legislation. According to Ward and Phillips, prior consultation to avoid clashes is compulsory. It is meant to gather views and minimize objections. Rules of law. The term rules of law is derived from the Latin phrase la legislatas, which refers to a government based on the principle of law rather than of man. Edward Coke originated this concept and Dicey developed it. According to Dicey, the rule of law is fundamental to the English legal system. Three distinct meanings of the doctrine. Supremacy of law. The rule of law signifies the supremacy of law. Equality before the law. Article 14. Everyone should be treated equally in the eyes of the law. Predominance of legal spirit. The supremacy of the court. Exceptions. There are few exceptions in this doctrine, which are as follows. The president and governor are excluded from the rule of law. The president and governor cannot be involved in civil cases. The president is not answerable to anyone. The president and governor cannot be arrested. Foreign ambassadors are also exempted under this exception. Okay, and the last one is there can be no discussions about Supreme Court or High Court judges in Parliament. Modern concept of rule of law. It has been given by Mr. Davis. The 7 principles are as follows. Law and order, fixed rules, elevation of discretion, due process of law or fairness, natural law or adherence to principles of natural justice, preference for judges and ordinary courts of law, judicial review of administrative actions. Positions of rule of law under the Indian Constitution. It is supremacy of the Constitution, constitutional equality, constitutional guarantees and judicial enforcement of the rule of law as a legal concept. Rule of law as a feature of the basic structure of the Constitution. Elimination of arbitrariness, compliance with legal requirements, fairness in action, public interest in social welfare and security, preamble and fundamental rights. There are also one famous case, Indira Gandhi Nehru versus Raj Narayan. The Supreme Court stated that the rule of law is a basic structure of the Indian Constitution. Ombudsman means local. The concept originated in Sweden and operate independently from the 3 organs of government. It addresses citizens' complaints independently, representing people against administrative authorities. Appointment under the Local Act 2013, Section 3. There is one chairperson. Chairperson may be ex or current Chief Justice or an eminent person. Members, 50% of judicial member and 50% of non-judicial members. Inquiries at the national levels. Inquiries used to be done at the national level. What are the object? To protect citizens' rights, investigate and any malpractice in the government, impart justice and hold the rule of law. Another topic is Lokayukta. Operates at the state level similar to the Ombudsman. Local, central level 8 members, 1 chairperson appointed by the president. State level 3 members, 1 chairperson, governor of the state. Selection of chairperson and member of Lokayukta. Prime Minister, Speaker of the Lok Sabha, Leader of the opposition in the Lok Sabha, Chief Justice and eminent jurist. Local jurisdiction covers all categories of public servants and all entities, NGOs receiving donations from foreign source in excess of Rs 10 lakh per year.